Hey everyone, it's your friendly neighborhood taxman here with another video about business. This week we're doing something different again. I get asked a lot of questions and sometimes it's all about the legal side of running a business, which I'm not qualified to answer. So I got my good friend Alex from Sprintlaw to answer these questions for me. Just in case you don't know, Sprintlaw is an online small business legal firm which specializes in business contracts, employment law, intellectual property, and much more. The team at Sprintlaw are also going to be posting this video, so keep an eye out for that. I want to also stress that this video isn't a sponsored video. We're not getting any money for this, and he's actually the one that's doing me a favor for answering these questions. So without further ado, here's Alex.
Just before we get started, it's important to mention that this video shouldn't be taken as formal legal advice, and the content I'll be discussing is just for general informational purposes only. It's always best to speak to a lawyer if you need specific legal advice on a particular issue or problem. Okay, so the first question is about protecting your business's intellectual property. What can you do? Well, there are two main types of intellectual property that you want to be thinking about in protecting your business: trademarks and copyright. I'll explain each of them in a little bit of detail. So let's start first with trademarks. Trademarks are all about protecting your brand name and product names. Trademarks give you the right to exclusively use a word, logo, or phrase in a particular country in a particular class, which is sort of like an industry. For example, Sprintlaw has registered a trademark for the word Sprintlaw in Australia in Class 45, which is the legal class. This means that nobody else can use the word Sprintlaw to promote legal services in Australia for a period of 10 years. We generally recommend businesses look to protect their business name and logo as soon as possible after getting set up with a trademark. So if you're going to be investing time, money, and effort in setting up your brand and promoting it, you really want to make sure that you own it. We've had many clients forget to register their trademark and invest in building and growing their business, sometimes for years, only to find out that another business already owns the trademark for their name. And this can be very costly and often means that businesses are forced to rebrand or face being sued. Trademark costs depend on how many words or logos you register, but generally start at around $1,000 if you're working with a lawyer. It is possible to register a trademark yourself via IP Australia's website for a little bit cheaper, but we generally recommend investing in having a trademark lawyer register your mark, as the process can be complex and time-consuming, and it's really easy to make mistakes. Next, we have copyright. So copyright is a bundle of legal rights which the law grants original creative works. And for businesses, it's all about ensuring that you own your original designs, software code, documentation, videos, and any other creative works that are produced in the course of your business. If you own the copyright for these things, it means that you'll be entitled to the exclusive rights to use them, and you'll have the right to sue anyone who uses them without your permission for copyright infringement. Unlike trademarks, you can't actually register your copyright. Copyright is, by default, owned by whoever created the work. The only real way to ensure you own copyright generated by someone for your business is to have them sign a contract that transfers ownership of copyright over to your business. For your employees or contractors, this is often done by including a copyright assignment clause in your employment or contractor agreements. For anyone else who has created imported creative work for your business, like web designers, graphic designers, videographers, or other suppliers, you should have them sign a copyright assignment agreement confirming that you own the rights in what they do. It's really important to protect your copyright before or as soon as possible after it's created. Otherwise, you could be sued for copyright infringement later down the line by the creators or be required to cease using the relevant creative works. And this could be really detrimental to your business. The next popular question is about getting started. What are the main legal things to think about when you're getting started with your business? Well, once you've registered your business, there are quite a few important legal things to think about. Firstly, you want to think about protecting your trademark. This will ensure that you have ownership of your brand and the exclusive right to use your name or logo in your industry. Secondly, you want to be thinking about your agreement with your clients. Depending on what kind of business you are, this might be called a service agreement, a business T's and C's, a terms of sale, or an e-commerce T's and C's, or something else. In all these cases, you just want to make sure that you have some legal document in place which protects you from liability, secures your revenue streams, and clarifies the scope of your offering to your clients or customers. Thirdly, you want to think about your agreements with business partners or co-founders. Any business with 2 or more owners should consider putting in place a founders agreement. Depending on your business structure, this might also be called a shareholders agreement or a partnership agreement. These documents set out the rules for how decisions are made, what happens when a shareholder or partner wants to leave the company, how disputes are handled, and other important matters. Other things you might want to think about are employment agreements for any employees you intend to take on, contractor agreements for your contractors, and website documents for your website, including a privacy policy or web T's and C's if you're collecting contact information on your website. The exact priority and order of what legal help you need really depends on your business model, and so it's important to speak to a lawyer as soon as possible to make sure you have all your bases covered and that you're protected against any legal risks. The next question on our list of FAQs is about service agreements. What makes a great service agreement? So a service agreement is a contract between a service provider and a client who is receiving services. If you're a service provider, it's really important to put in place a bulletproof service agreement to help protect you against legal risks, clarify the scope of your service offering, and ensure payment terms are clear between you and your customers. These documents should set out the scope of the services that are being provided. For example, what deliverables you'll be delivering, what the cost of those deliverables are, and any fees for work that is not included in the agreed scope. It should also include important clauses to protect you against risk if things go wrong, including limitations of liability and indemnities, payment terms, and clauses clarifying intellectual property ownership. For example, let's say you're a web designer and you'll be designing a website for a client of yours. You've given them a fixed fee quote to make a certain number of web pages. A service agreement can help here in a number of ways. Firstly, if your client keeps asking you for more and more changes or additional pages, you can include a right to charge them additional fees. Also, if they aren't paying their invoices on time, you could have the ability to stop work or charge them interest on outstanding payments. If the site goes down or breaks in the future and your client ends up losing a whole bunch of potential money from lost sales, a service agreement can help protect you from liability from that. And if you want to reuse the website design with future clients, a service agreement can help allow that. As you can see, these things are pretty useful, and the same logic applies to all kinds of service providers, whether you're a web designer, accountant, tradesperson, or consultant. Alright, so this question is about websites. What legal information do you need to include on your website? Well, there are two key legal documents that businesses typically include on their website, and these are website T's and C's and a privacy policy. Privacy policy basically discloses to users how you'll collect, store, and share their personal information. Personal information is a legal concept set out in the Privacy Act, and it includes anything about a person that could reasonably be used to identify them. Think, for example, name, phone number, or email address. Many businesses are required by law to have a privacy policy if they're collecting personal information. And even for those who are not, it's really common practice to let customers know what you're doing with the information when you collect it. Website T's and C's include important disclaimers to users of your website. So if they're hacked or suffer a malware attack while on your site, or navigate to a third-party website and have some issue, your website T's and C's can help protect you against liability. They also confirm your intellectual property ownership and any blog content or other information you've shared on your website, and notify parties that they can't copy your website content without your permission. If you sell goods or services via your website T's and C's might need to be a little bit more detailed. So it should include, for example, information about your payment terms, shipping or returns policy, and any other liability or risk disclaimers specific to the type of goods or services that you're selling. Now, this next question is all about lease agreements. What you should look out for before signing a commercial lease agreement. So a commercial lease is a contract that sets out the rights and obligations of the property owner and the person who'll be occupying the premises. The property owner is known as the landlord or lessor, whereas the person occupying the premises is known as the tenant or lessee. Before entering into a commercial lease agreement, it's really important to make sure that you understand the key clauses contained within it and ensure that it allows you to do what you plan to be doing for your business, both now and in the future. For example, if you're thinking of using the premises for a while, you really want to make sure that the agreement includes an option to renew. This means that when your lease is about to come to an end or expire, you'll have the choice to continue trading using those premises after the initial term. You'll also want to know what rights the landlord has under the lease to end or terminate your lease, and how much notice or compensation you'll be provided. This can be a major business risk, and so it's very important to understand how this works so you can plan around it. You also want to make sure that your contract permits all your intended business activities. For example, what restrictions are there on using outdoor areas? Can you put tables and chairs in the places that you want to? In addition to these, there are a number of other kinds of issues that may affect your business, and it's always a good idea to have a lawyer look through your lease and advise you on it just before you sign it. Okay, and the last question, what are the key considerations when drafting a shareholders agreement? A shareholders agreement is an important contract between the owners of a company. It's very important to have a shareholders agreement in place because it clarifies the rights and responsibilities of key stakeholders in your business, like founders, directors, investors, and other shareholders, and sets out the decision-making process for the business. The key sorts of things you can deal with in a shareholders agreement include how decisions are made, What happens if there's a dispute or disagreement between shareholders? What happens if a shareholder wants to leave? What's the relationship between the directors and the shareholders? And how are new shareholders brought on, and what rights will they have? You should cover these all in quite a bit of detail in your agreement, and it should really be tailored to your specific business requirements and your business goals. We've seen too many businesses fail due to misaligned expectations between shareholders, which could have easily been avoided with better communication facilitated by an upfront shareholders agreement. For this reason, we always recommend businesses put in place a shareholders agreement as soon as possible after they're set up. So there you have it, a few popular legal questions about the legal aspects behind running a business.
Thanks again, Alex, for answering all those questions that all small business people ask. Don't forget to like this video and subscribe to the channel for more business and accounting tips, and possibly some legal tips. And also check out Sprintlaw for all your legal business needs. See you next time.